Welcome to class number 7. Today we'll be analyzing civil procedure. And like in our class that we're going to have about criminal procedure, you should be informed. Civil procedure varies immensely depending on the state, on the jurisdiction. There are a lot of rules, so it's difficult to have a standardized understanding of what the civil procedure norms are, especially because we're analyzing common law in general. Obviously, the class is about American civil procedure, but I'm hoping that we can learn the vocabulary for all jurisdictions, just the basic vocabulary, so that you can go then and research and learn the rules of the specific case you're working with. So American civil procedure, jurisdiction, that would be basically what the court is. The word jurisdiction is sort of a false friend because the term in Portuguese has a completely different meaning. Basically, we're talking about who has the ability to hear the case. That's going to depend, based on where the person lives and what's being discussed. So before the case begins, you can have a motion to change venue if you think that the case should be heard somewhere else. Pleadings. So the important word that you should learn today is the word plaintiff and defendant. So the plaintiff is the person filing the complaint. When you enter a civil proceeding, you file a complaint against someone, and that person is the plaintiff. And the defendant is going to be the person that is being accused of a certain thing. Basically, if you file a tort claim for, some sort of wrongful injury, you're going to be the plaintiff in that case, and the defendant is going to try to defend themselves for your claim that you're going to file in your complaint, usually seeking some sort of monetary compensation in the form of damages. So discovery, you have the right to obtain information from each other. You can't really surprise the other party with evidence. You have, there has to be cooperation between the parties. This is something we have adopted for our own civil procedure, where both of you are cooperating to construct a narrative that the judge or eventually the jury will rule on. Basically, motions. You can have a motion to dismiss if the case is absolutely bogus, or a motion to change venue, or a motion for summary judgment. So basically, summary judgment means you skip several steps of the procedure, you just go straight to the judgment. If you think your case is completely clear-cut, or the other party, the defendant, offered a defense that was extremely weak, you can just have a motion for summary judgment. The trial, basically, you are going to present your arguments and evidence either to the judge or to the jury. That's going to depend on which kind of case it is, and we're going to go over that. So a jury trial for a civil proceeding to us is a very strange thing, but it is an important aspect of both American and English civil procedure. Appeals, obviously, you're allowed to appeal to a district court if it's a federal, if you're in a federal justice system, or to a higher court within the state, or eventually the state Supreme Court if you're in the state courts. But basically, you're allowed to appeal. Jurisdiction, again, is just the authority of the court, and the venue would be, the geographical location. Standing, this is important. Standing means you have the right to bring a lawsuit. Basically, standing would be close to us to this idea of having, interesse de agir, legitimidade. So that's what standing is. If you file a complaint on a case where you have nothing to do with what happened, you have no standing. You cannot bring that case before the court. Pleadings, basically the things that you're asking for or the things that you're arguing in your complaint or in your defense against the complaint. But it's important to note a lot of the proceedings are done orally. Obviously, you're going to introduce the case with the complaint. If you're the plaintiff, you're going to have your initial pleading in the complaint, but most of the case itself is going to play out in the court with oral arguments, especially if it's a jury trial. The answer is going to be the answer to the complaint by the defendant, and the counterclaim eventually is going to be a claim that the defendant fills in the response to the plaintiff's complaint. So basically, you can think here of the idea of in our own system of filing a claim at the end of your defense against the petição inicial. You can have your own claim at the end of your response if you think that the plaintiff is abusing the justice system, or if you think that the plaintiff is suing you when you should be suing them. So basically, we would refer to that under the term, basically the counterclaim in our system would remind us or be similar to the idea of a reconvenção, right? So basically a claim that you feel against the plaintiff's complaint. So basically, maybe they're suing you when you should be suing them. Discovery, like I said, you have the right to obtain information from each other. There's no secrets in the court. It's not you're not There's no surprise evidence. The deposition, you're going to depose in the court. That means you're going to be under oath, so you're not allowed to lie under criminal penalties. And basically, you're going to present a version of the facts. That's going to depend, obviously, on the case itself. But a motion to dismiss, if the case is completely bogus, if the other party doesn't have standing, so if the plaintiff has no standing in the case, you can file a motion to dismiss. Basically, and the motion for summary judgment. If the defendant, presents a very weak defense, you can have that motion. So basically, summary judgment would be the case being decided without a trial. The judge, obviously, he's going to be presiding over the trial, or he's going to be deciding. It's going to depend. If it's a jury trial, he's just going to be presiding over the trial. If it's not a jury trial, then he's going to effectively issue a decision. And the verdict would be usually refers to the judge's decision and to the jury's decision. So in this case, in the jury trial, in the civil case, you do not need a unanimous decision by the jury. A demurrer, this is interesting because basically it means to the defense that you make in your own favor. So when you're questioning the other party's pleading, we can think here of the idea of a exceção in the sense of a legal defense. So that's a demurrer. So general demurrer, or you can basically allege that there's a huge problem such as improper venue that basically threaten the legality or the validity of the other party's claims. Or you can have specific demurrers, such as basically there's not sufficient evidence or this evidence is not good. So basically a demurrer is just a general term for something you argue in your own favor. Stoppel, this is interesting. Stoppel basically just means it is equivalent to both. In our system, I'm going to go into detail later about this, but there are similarities. It's not equal, obviously it's not the same, but there are similarities between stoppel with both the idea of coisa julgada and the idea of preclusão. So basically, if there's already been a decision in the defendant's favor or in the plaintiff's favor, then there's stoppel against that claim. Or if the defendant or the plaintiff missed their opportunity to complain about something or to allege something in the court, then there's also stoppel. So that they cannot claim it later when they failed to do so before when they had the opportunity. Non-suit, basically the case is dismissed. Basically when you have a motion to dismiss the case, basically perhaps the plaintiff has no standing, so the judge will just rule the non-suit because the case has no value and there can be no decision either in the defendant's favor or against the defendant. A remand, basically, when you file a motion to appeal to a higher court, and they're like, well, there isn't enough evidence here, or this wasn't discussed well enough, they send it back to a lower court. So basically, this happens even in the Supreme Court. They're like, well, we'll send this back to the lower court so this can be, analyzed further. So basically, we'll remand that to a lower court. Or federal agency, sometimes when you sue the government, you can also remand that to the federal agency. So yes, like I said, the person who files the complaint and the lawsuit is the plaintiff. This is an extremely important term. And the person who responds to the complaint is the defendant. So it's the same term for criminal and civil proceedings, the defendant. This term here is different. So it's a plaintiff in a civil case. In a criminal case, you usually refer to it as the prosecution or the district attorney's office. Yes, so jury trial. The 7th Amendment to the U.S. Constitution ensures the parties have the ability to have a jury trial in a common law case at a federal court. And also, if the state wants to adopt that rule, they can. They're not mandated to. Only about half the states ensure jury trials for common law cases in civil matters. But the federal courts have to have jury trials. This is good because a lot of cases, there is, if you think something like a class action lawsuit, it's good that there's the validity of a jury trial to preserve, popular interest in that claim. Especially because, like I said, the judges, sometimes they're elected, so there could be, political interests that come into play which impact that judge's ability to decide, and that doesn't happen with the jury. Basically, same thing here, Colgrove versus Batten, just upholding that idea that we will learn in criminal proceeding in our next lessons, that the jury has to have at least 6 people in order for it to be an effective jury trial. Voir dire examination, so in French, voir dire, basically is when you examine the judge to see if they are fit to serve, if they don't have any biases, if they have interest, if maybe they have interest in the case. So it has to be a cross-section of the community, but it also has to be people who are impartial to the case. Suits of common law, extremely important to determine this when you're analyzing civil procedure. So I brought here from the case Grand Financiera versus Nordberg. Basically, the Supreme Court said, we have consistently interpreted the phrase suits of common law to refer to suits in which legal rights were to be ascertained and determined, in contradistinction to those who were equitable rights alone. So when we talk about equity, there's the idea that equity doesn't create law, it just assists it. Actually, it's right. And this is repeated here in Slocum versus New York. Basically, the rights that existed, the common law of England, with this body of rights and customary laws that existed, and when those things were insufficient, then you could step in with an equitable remedy, which is why you say equity corrects errors and equity does not make the law but assists it. You see here the definition from Black's Law Dictionary. It's a very good source for American law. In a lawsuit that will be determined according to the court's judgment of what is fair and equitable. So it's a remedy, really. So since in the federal courts, equity has always acted only when legal remedies are inadequate, the expression of adequate legal remedies provided in the federal rules necessarily affects the scope of equity. Basically, when the common law is insufficient or when there's a gap in the common law, you step in with equity. Basically, discovery, like I said many times, before the trial begins, you have the right to know all the evidence that exists and the other party has. You're not going to surprise the other party. There has to be some sort of cooperation among the litigants. Here, this stuff we've gone over. You have the right to cross-examine witnesses in a civil trial as well. You ask the witnesses questions, and the other party goes and asks the witnesses some questions. And you can produce documents. You can bring expert witnesses, and the other party can challenge your evidence before the judge, right? So if you bring an expert, the other party, the opposing counsel, doesn't think that person really is an expert, they can challenge that witness. Or if they think that a certain witness has a certain bias, or maybe they have some sort of personal connection to the case, you can impeach the witness and basically say, well, you're friends with the defendant or you're friends with the plaintiff, you're not able to be a witness in this case. Physical and mental examination. Well, basically, this is the type of expert witness evidence. So this is something that also can be used in the case. Pre-trial motions, like I said, motion to dismiss, motion for summary judgment. In some cases, you can, request a jury trial if it's a case where, the jury trial is not mandatory. The parties obviously can agree to waive it, even in a federal court. So you can have a motion to have a jury trial. And the judge is basically going to decide, well, is this really an equity or a common law case? And that's going to determine whether you have the right to a jury trial in a federal court system. Opening statements, like I said, if it's a jury case, there's a certain element of theatricality. So you have to present a good jury case. Imagine if it's there's a famous movie from I think the 1980s or 90s where there was a person who was dismissed for discrimination because that person had HIV, and I put that in the exercises. And he sued his former employers for discrimination. So in the movie, basically the person's attorney presented opening statements, talking about the importance of fighting discrimination and respecting diversity. So this is just something to acquaint the jurors who are going to be normal people with the peculiarities of the case and maybe try to impact them also emotionally so they'll be invested in the outcome. Cross-examination, like I said, after the witness, the plaintiff presents a witness, the defendant has the right to go and cross-examine the witness afterwards. It's not just the witness is going to have to answer to both parties, not just one. Closing arguments, it's going to be in the same vein as criminal proceedings. Basically, you present a conclusion. So you present an opening statement, you support that idea that you had in the opening statement with evidence, and then you present a closing statement, which is really to persuade the jurors. It's not really for the judge, and it's not really going to be based on very technical reasons. It's more so going to be presenting the narrative that you want to be victorious in that case. The instructions, because civil trials are a bit more complicated than criminal trials in the sense of what the jury is deliberating about, they have to be instructed on what exactly it is that they're voting on. Because in a criminal trial, it's simple enough. You just say, well, is the person guilty or not guilty? But in the civil trial, you have to think, well, what are you voting on exactly? So the jury has to be instructed. And after that, they will deliberate and they will reach a conclusion which does not have to be unanimous. It depends on whether or not, it depends on the case usually. Right. So, and then the jury will deliberate on the case, and they have to reach a unanimous decision in the federal court system. And this is also something that applies to criminal cases. In the state system, there's some room to decide whether the cases have to be unanimous or not, but in the federal system, they have to be unanimous in both civil and criminal trials, so there has to be a unanimous decision. And this matters because when you have a suit of common law, you're basically determining whether a right exists or not, so that's going to influence a lot of people, so it's good to have a unanimous decision. Then once the verdict is reached, you may be ordered to pay damages, so you can have compensatory damages, and we're going to analyze this when we talk about tort law, kind of compensatory, punitive damages, exemplary damages. Like I said, the jury has to be instructed carefully on what exactly it is that they're voting on, because it's not as simple as a criminal trial where you're voting on a guilty or not guilty. But there's also jury instructions in criminal cases, I should make that clear. You're also voting on several, the jury also always has to be instructed because it's made of normal people. So they have to know exactly what it is that they're voting on. And here's just basically the same things that I've explained. Just to reiterate and make it clear, you can request the production of documents, you can interrogate, you can call on your own witnesses, you can request for certain kinds of evidence to be admitted or not admitted. You can have some sort of written statement. An evidentiary hearing, basically when you present the evidence, usually in order to have an injunction in your favor. So basically an injunction is a temporary court order that orders someone to do something. So this is really something that is similar, but obviously there's lots of differences, to both the idea of tutela de urgência, tutela liminar. So basically all these things, they can be grouped under the idea of an injunction at a court. So basically you have an evidentiary hearing in order to see if there's enough evidence for your injunction to be granted. Subpoena means basically that you've been called to testify before the court, and that is mandatory. You cannot defy the subpoena. This is something that happens a lot in congressional hearings because the Senate has the authority to sort of act as a court when it does, for instance, an impeachment trial or a Senate hearing. It can subpoena people for the hearing, but the courts can do that as well. Basically, you subpoena a person in order to testify, or you can subpoena a person to provide a certain document. So it's basically just a court mandating that someone who isn't necessarily directly involved with the case do something. So yeah, you have several civil procedure rules to determine when and how the person is going to be subpoenaed. Affidavit, this is important because it basically is a written statement that has been recognized by a notary public. So basically when you write that down and you take that to a notary public, the notary public here, obviously many differences, but you can tell that the term is similar to the idea of a notario, the idea of going and getting something to be affirmed. For instance, notabilidade notas, those are similar ideas. The notary public is going to be this person that has the authority to make these private documents have this sort of credibility before the courts. So basically you have a written statement and you take it to a notary public and you're sort of bound by it. If you want to submit a written statement to a court and you want it to be viewed as valid and you want the court to know that it was made by you and that you swear by what is on the affidavit, you take it to a notary public. Basically, if you want to provide evidence in the form of a written document, you can have an affidavit, or you can verify that that thing is real. So you can also have an affidavit. Basically, many uses for an affidavit whenever you have to submit written information to a court, and you want the court to know that there's some validity, and that the person who said that is really the person who said that, and or maybe that you want to have an expert say that what's on the affidavit is true. You do not use the affidavit to present your lawyer. You file what's called a notice of appearance. So basically your lawyer will send the court a notice of appearance informing them that they are your lawyer and that they are legally bound to represent you and your best interests, and that they cannot act in a way which would be a conflict of interest. And they are bound by this notice of appearance until they file another notice saying that they've left the case. They have to have a motion to withdraw from the case. If after they file the notice of appearance, they're sort of bound to represent you, they can't just abandon you for no reason. So cross-examination, like I said, the other party's attorney, the opposing counsel can come and also examine the witness that you called. So you don't own the witness. We have the same thing here. It's really an important benchmark of any trial. If you think the witness does not have credibility, or maybe they're too involved in the case, you can impeach the witness. So impeaching the witness, sort of similar to the idea of a contradita here in our system. Basically, you can clarify and challenge the testimony. You can test the witness's knowledge. If someone calls forth an expert witness and you have reason to believe that person really isn't an expert, or maybe you have reason to believe that they weren't at the place, or that they really don't know what they're talking about, be it because it's like a technical matter that they don't have knowledge of, or maybe they just weren't there at the time. Then you can question their knowledge, or you can ask for additional information. So when you see people objecting, they can object to many things. So for instance, this is irrelevant, this is not going anywhere, or this is hearsay evidence, basically meaning that if a person goes to the witness, as a witness to testify, and they say, well, I heard rumors about that, and that's hearsay evidence, and that is not admissible in court. Basically, the cross-examiner will go to the witness after they've presented their version to the party that called the witness. The opposing counsel will go and make sure that the version presented by the witness is actually consistent. They're going to try to poke holes into it, sort of undermine their credibility. Well, like in the criminal case, when you want to appeal the verdict or the decision by the judge, you have to file a notice of appeal. And that's going to go, either to a district court if it's in the federal system, or to a higher court within the states. But basically, you have to filed this notice of appeal, where you basically just tell the court why you think the sentence was not, the decision was not good. File the appellate brief, where you're going to put your arguments. You have an oral argument, because it's important to have oral arguments in basically every step of an American trial, both criminal and civil. They rely a lot on oral proceedings. So even though you file, a written complaint as a plaintiff, or you file a written defense, of a written counterclaim as a defendant, you still have to have these oral arguments. This is interesting because they will only reveal the legal issues, especially in a jury trial. When we're dealing with the facts as the matter, what happened, the common law aspect, that's going to be respected if the jury deliberated a certain way. So the higher courts will usually focus on legal aspects and procedural aspects. They're not going to say, well, the jury was right or wrong, because then there wouldn't be much point to a jury trial. Per curiam is just something that's important when you're reading decisions, not to get lost. It just means by the court, because usually when you read a decision, each judge or each justice, the judges at the American Supreme Court are called justices, each judge would issue their own opinion. So in the district courts, you have trials with several judges. In the Supreme Court, you have 9 justices. But when it's per curiam, means it's the opinion of the entire court, and they don't sign their individual names, because usually that's what they do when they issue an opinion. They put their name on top of it. This is an interesting, because this is a tort claim, and I'm going to analyze it in our tort class. Basically, it's talking about estoppel, right? So in the case, a bench fort failed to object to any of the matters it now complains about during plaintiff's arguments to the jury. Thus, none of the matters Fort now complains about were matters to which an objection was interposed, and a request for admonition, being basically advising or criticizing something, for admonition made in the court below. Fort is therefore precluded. So the verb precluded, but the phenomenon is called estoppel, from raising the contention of misconduct unless they were such as could not have been cured by admonition. Basically, if you missed your opportunity to argue something at the right time, then that right is precluded. It's basically the same term we use here, preclusion, but the phenomenon is also called, itself is also called estoppel. So basically, if you had the opportunity to do it and possibly solve it through the admonition, so through the warning by the court, then you can't do it later. This is good here, because this is what we're going to analyze during our corporate law class. This is U.S. versus Microsoft Corporation. It was a case under the Sherman Antitrust Act. They were arguing whether or not Microsoft had a monopoly on the computer industry, and they were basically arguing that Microsoft could not issue that objection anymore because they could not prove that they had been effectively damaged by it, and they had not done it in the right time. So basically, they have to show that the procedural mistakes had substantial prejudice to the complaining litigant. So you cannot just issue an appeal based on some minor procedural mistake which didn't impact the case. We have the same idea today, and it's good because it shows the approximation, and it shows that our civil proceedings have become less formulaic, because minor mistakes which don't impact the outcome of the case cannot be used in an appeal, and cannot be used to sort of try to dispute the verdict. So that's basically what the district court said in this particular case. A conveyance action, this is just to some more vocabulary, basically an action to force the property transfer to go through. We would call this adjudicação compulsória. So basically, you buy a piece of property and the person doesn't want to transfer it to you, so you can use a conveyance action to force them to. Conveyance meaning, the act of transferring property from one person to the other. Statutory action, basically, it's an action that's based on written commands, written provisions. So statute, as I have said before, it means a written piece of legislation, because the law is an all-encompassing term that means many things. So statutory action is based on an actual written piece of legislation. Damages, you can have compensatory damages, punitive damages, and nominal damages. But nominal damages are interesting because, whenever you file a complaint, you have to basically sort of put a certain monetary value to it. So if you want to complain, if you file a complaint, just for sentimental or symbolic reasons, you can have just nominal damages. But basically, it's the monetary compensation that is to be paid at the end, or the compensation that is to be given to the plaintiff if they are victorious in their case. Injunction, like I said, is something that the court does that is meant to be temporary and to relieve a certain situation that cannot wait until the case is finalized. So you can have a preliminary injunction, which would be this temporary order, and also a permanent injunction. This sort of escapes the meaning that I said before, the association with the idea of a liminar and tutela provisória. Because like I said, the terms in legal English, they're not equivalent or synonymous. They are approximations, and obviously every legal term is going to have a different meaning in every legal system. A permanent injunction to us would not make sense, which is why, when you think of injunction and you associate it with our system, you're probably thinking more of a preliminary injunction. So specific performance, we're going to talk about this in contract law, basically means that you don't want monetary damages, you want the person to actually do what they were supposed to do. So you want specific performance. And also, declaratory judgments, we have that here as well. You just want something to be declared in your favor. You're not specifically looking for a monetary reward at the end of the trial. Reformation, you're allowed to rewrite the contract in a way that, it would not be abusive or would not, be against the law, or you can rescind the contract. So when we're talking about Sherwood versus Walker, we're going to talk about that in the contract law. The contract was just undone, and all the effects of the contract basically were undone. So the contract was rescinded. And here you have some relevant case law. Like I always say, this is just the beginning. I picked this, mostly so you could learn the terminology. If you read this, you're going to be familiarized with the terminology. Like we're going to talk about during the contract law class, the civil procedure is a huge field. It's a very complicated field. You're going to have to read hundreds and hundreds of cases to really gain an understanding of it. These are just some cases to help you learn the vocabulary that's associated with the American civil procedure. I'll see you all in our next lesson.